have been misled when they ruled on the applications for leave of conviction in the May of last year. Dr. Evans has also said that he has revised his opinion in relation to baby C and has written a new report that he has given to the police. This was some weeks, actually months ago now. Despite numerous requests, the prosecution have yet to give this report to the defence. The defence will argue that Dr. Evans is not a reliable expert, and given that he was the lead expert for the prosecution, we say that all the convictions are unsafe. The second statement I'm going to read relates to fresh evidence. Fresh evidence relating to two very detailed and lengthy reports, one on baby C and one on baby O. And let me read out the statement by the two neonatologists. We have been instructed by solicitors representing Lucy Letby, and so far we have examined two cases, baby O and baby C, in great detail and presented joint reports. To prepare these reports, we had full access to the following: the hospital notes, the post-mortem records, multiple reports of David Evans, as well as other experts' witness statements and statements submitted as part of the pre-trial investigation. I should also add, as well as transcripts of the trial as well. We have taken considerable time and care, and these reports provide a thorough analysis. Our reports demonstrate that there are identifiable medical reasons why both babies became unwell, sadly did not respond to resuscitation, and subsequently passed away. We have set out clearly within our reports evidence showing that these babies could not reasonably be described as well or stable. Neither should their deteriorations be described as unexplained. Our reports contain careful, justified new evidence which has not been presented before, either in court or as part of previous examinations of these cases by multiple sources. It is not our role to determine any impact this new evidence might have on the legal process. Although some of the medical information within the reports is complex, it is possible to draw clear and sound conclusions which we believe will stand up to scrutiny. In this respect, we are completely happy for our reports to be subject to appropriate independent expert critical analysis. We have provided evidence that baby O died due to issues relating to the resuscitation. Baby C died due to problems caused by failing placental function at the end of the pregnancy. We have seen no evidence of deliberate harm to these babies by anyone. Despite the huge public interest, we fully understand the reports have now been submitted and we cannot make further statements or comments at this stage. The release of limited experts or brief soundbites would not do justice to the detailed arguments and conclusions made within the reports as a whole. That last paragraph, in effect, they are not going to be making any more public comments about their own reports. Now, those are the two statements. There may be some questions either from me or the neonatologist on the panel or anybody who wants to address statistics. So I'll open the floor up. Any questions?
I've got one.
John Sweeney.
Yes, so John Sweeney. You say that Downey Evans is should no longer be considered to be a reliable witness, a reliable
Yes. Dr. Evans has given a number of interviews following the conviction of Lucy Letby to newspapers, documentaries and podcasts. In those interviews, he has said a number of things and has said things that are inconsistent with some of the evidence that has been served and that I have seen. That's the first issue I have with him. I think it's remarkable that an independent expert who gave evidence for the prosecution continues to speak to the media and is continuously on TV and in podcasts and giving interviews. But that is aside.
Can you explain in simple terms what he said in court and what he said since?
Yes.
And why that causes you trouble?
No, of course I will. So we know that he was the lead prosecution expert, and he was the first person to examine the notes of the babies and give the first initial reports. He has come up with, in essence, 3, maybe 4 ways that he says collapse was due to these babies, of which some of them ultimately died. Air embolism being a primary one. Second to that is air, he says, being injected down the nasal gastric tube, causing a splinting of the diaphragm, which has led to suffocation, which has led to the death. He has now said that that is not how the babies died. He said that 1 year after Lucy Letby was convicted. So you have a person who went before the jury, gave one theory, and then has now said that that is not the theory that he doesn't longer stand by. He says that is not how they died. Now there is one caveat to that, and that's baby P, because in baby P it's slightly confusing because it's air down the nasal gastric tube, but he also added, it would seem, air embolus as well. So I put that caveat in my statement, but certainly in relation to baby, the other 2 babies, that is correct. And that's what the Court of Appeal was told. And that's the important thing. Sometimes Dr. Evans did change his view, certainly on one occasion, whilst giving evidence. But the Court of Appeal were not, the prosecution did not stand by that in the Court of Appeal. They said the child, particularly baby C, died as a result of air going down the nasal gastric tube. And that's what causes us concern. So we say, and it's a theory that we need to put before the Court of Appeal, that we want them to reopen their the last judgment and to re-look at it and to decide whether or not this expert, this lead expert, is reliable. And if it's not reliable, then all the convictions we say fall. Jonathan.
Jonathan Coffey. Can you tell us any more about what Dr. Spillane and Dr. A mean by issues related to the resuscitation and failing central function? And secondly, what if other experts that you're working with offer different theories to those?
All right, I'll answer the second one myself, but then I'm going to ask Dr. Richard Taylor to address the issue in relation to the 2 reports, if he can. So there are, at the moment, just over 15 experts working on these papers, the medical records, all the statements, and they have access to everything, to give an opinion as to the cause of death when it's murder, or cause of deterioration when it's attempted murder. Those international experts are based all over the world, in America, Canada, Japan, Germany, Sweden. They are working on them at the moment. And I have had nothing to do with that process apart from give them access, and my instructing solicitors instructed them. And they have simply are working in the background. I expect to receive those reports in January. Now, Jonathan, you're absolutely right. If there is a tension between the reports that I get in from the international experts and those that I'm obtaining from the domestic experts, because the two domestic experts I'm talking about, Dr. Ayton and Dr. Dimitrova, are continuing to work on the babies. I know already that they are made significant progress in relation to baby F and baby P. So they're continuing to work on those. I don't have final reports yet. The tension is if there is going to be a tension, and we don't know because we're now in the realm of speculation, would be between how a child may have collapsed or died or deteriorated and the medical rationale for it within the medical notes. So I may find myself with two theories or two hypotheses, but neither of them say that this child was deliberately harmed. It seems to me that goes with the complex nature of what is happening here, and the CCRC should examine that.
Mark, Anoop Curry, it's
Hello.
a really unusual step that you're taking here in going directly to the Court of Appeal. Is it unprecedented, and how much confidence do you have in it being considered?
It is unprecedented. It's a rarely used device. There's authority on it, predominantly in the civil area of law, but there are criminal authorities on it. But one of the aspects is that we also have another remedy, which is the Criminal Cases Review Commission. But my argument is the Criminal Cases Review Commission is there to look at fresh evidence. This is not fresh evidence. This is the lead prosecution expert who has changed his mind, and the Court of Appeal may not have been told the accurate picture as a result. That in itself, I think, makes it unique that they need to relook at what they have decided already. It's done in writing. I will draft the application, and I've drafted it. It's going to go in. That application will then be decided by a judge as to whether or not he or she will allow the Court of Appeal to reopen it. But it is rare. In fact, it would be, using your term, unprecedented.
And do the judges know this is happening?
They do now.
Mark, Charlotte Lynch from LBC.
Hello.
Presumably Lucy Letby knows you're making this statement today. How does she feel about that and the prospect of the case being reopened?
Everything I do is with the consent of my lay client and my professional client, my instructing solicitor. How would you feel? How would anybody feel? You're a 34-year-old woman, you've been sentenced to life imprisonment without any hope, and suddenly we found such profound and significant evidence that may possibly overturn your conviction. I leave it to you to decide how you would feel about that. Hello. Can you introduce yourself, sorry?
I'm Victoria from Sky News.
Hello.
Victoria Bird. As you said, the Criminal Cases Review Commission would normally be the route when convictions are dismissed in the Court of Appeal. So how sure are you that this is not fresh evidence? How is it distinct that you can't use that legal route?
I'm going to answer that question, but you know what I forgot to do? I forgot to bring Richard Taylor up here to answer part 2 of the question that I had earlier. I think it was from you, Jonathan Coffey. So I'll answer yours, and then I'll hand over to Richard Taylor. The CCRC is the remedy that is used for fresh evidence. Those 2 reports that I've mentioned will be going to the CCRC. I will be making an application at the same time to the CCRC. That is happening. CCRC can take years. I have one case with the CCRC that's in its 8th year. And so they will take a long time to deal with these issues. They may get their own other experts to look at what we put in. Months and months and years will go by. This is a different route which I'm allowed to use and I'm going to try and use. Does that answer your question?
If you're given leave to do so.
Absolutely, I've got to have permission to reopen the appeal. I have to apply for that. But I'm doing both routes in parallel. So they'll both be going on at the same time. Can I hand over to Richard Taylor, who's going to deal with those reports? Can you come up here? Is that okay? And it's on the two reports. I mean,
Do I have?
Yes, yeah, but not.
Yeah, my name's Richard Taylor. I'm a neonatologist from Victoria, British Columbia in Canada. But as you can tell from my accent, I'm originally from the UK. In fact, I trained at Barts, qualifying in 1980. So with regard to these reports, I've only read one of the reports in full, and that is the report on baby O. I should qualify this by saying that I have not seen the medical records myself, but I have read the full report. And to summarize the medical evidence, baby O was doing reasonably well. There had been some concerns with abdominal distension, which was possibly related to excess gas going into the gastrointestinal tract. The baby had an apnea, and the medical staff, an apnea is a pause in breathing, and the medical staff responded to this by intubating the baby, placing the baby onto a ventilator, and baby was not unwell particularly, but it had an apnea, but they placed the baby on a ventilator and then put the baby on very high pressure settings. So in neonatology, when we ventilate babies, we ventilate by pressure rather than by lung volume. And this baby was placed on very high pressure settings, inappropriate for the fact that the baby actually had no lung disease at all. So the baby was being ventilated on very high pressure settings. Again, the nurses were concerned that the medical staff had actually left the unit. They then came back. Things didn't look quite right, and to summarize what happened, the nurse was again concerned that the abdomen was distended, and one of the doctors responded to this by placing a needle into the abdomen. So they directly aspirated the abdomen, and they chose to use a point which in medical parlance is called McBurney's point. This is a description of the point that is used for performing an appendectomy. The baby did not need an appendectomy. This is a newborn. Appendectomy is completely irrelevant to it. If an aspirate was going to be attempted, it should have been done on the left side, but in fact the doctor used McBurney's point, which is on the right side. As I have already said, the baby was on very high pressure settings, and this is confirmed by an X-ray of both the abdomen and the chest. And the settings were so high that the baby's liver was pushed right down into the pelvis. So when the doctor performed the aspiration of the abdomen, the needle perforated the liver. The baby was still being ventilated with a needle in the liver. The liver was now being lacerated by the needle. And this led to bleeding, free blood going into the abdomen. The baby went into shock. The shock was actually confirmed by a subsequent blood test, which showed that the baby's hemoglobin had halved, and they were unable to resuscitate the baby, partly because they didn't realize what they'd done.
What was the name of the doctor?
I don't think it's right that we name names at this stage.
I think the doctor knows who they are.
We don't.
I know. I have to say, from a personal point of view, that if this had happened to me, I'd be unable to sleep at night, knowing that what I had done had led to the death of the baby, and now there is a nurse in jail convicted of murder.
Having looked at the evidence, how strong do you think the evidence against Lucy Letby is compared to your theory? That, as I understand it, the doctor accidentally killed the baby by mistake.
The claim was that I think that Lucy Letby had injected air into the baby. I'm not even sure what the prosecution was claiming, but it's nonsense. Complete nonsense. The baby died from shock, from a liver perforation.
How confident is the team in this, that this is what happened?
The report stands out, and I understand that the report is partly based on, well, it's fully based in fact on the medical records, and the medical records actually include a statement that an aspiration of the abdomen occurred at McBurney's point.
Is it surprising that that wasn't discussed in court?
Very surprising, yes. I don't think that the case was reviewed very well. It's also surprising that it didn't come out in the autopsy. But I understand that the information that an attempted aspiration of the abdomen had been made, this was not conveyed to the pathologist. The pathologist was unaware of that.
Could I just ask you, is this information that you just given, was it available to the prosecution at the time of trial?
Yes.
Prosecution knew of this at the time of trial?
Well, they should have done, yes. It was available, yes.
They had the information?
Yes, it was in the medical records.
Could I just ask,
Yes, ma'am.
would the doctor have known what they'd done? I just want to be clear about that.
Did the doctor know what they did?
Yes, after.
If it had been me, I think yes. I don't know whether they felt uncomfortable about it or what. I can't comment on that.
Can I ask if the doctor gave any evidence in the case against Letby?
I believe so. Yeah.
Was the doctor granted anonymity while giving evidence?
No.
May I
You
add
can-
something?
Yes.
The-
Do you want to come up and?
No, it's a very short point.
Okay. Yeah.
I'm aware that the second prosecution expert felt that the needle had been inserted at a level higher than McBurney's point, and of course that would mean that there would have been a much even greater chance of the liver having been perforated by this inappropriate action during the resuscitation.
That's
And,
yes.
and that
Yep.
they were aware of this.
Yeah. Apparently there was a photograph, and the incision mark appeared to be higher than McBurney's point, which makes it even more it makes it even more consistent with an injury to the liver. And the other part of it is that when the needle was inserted and the doctor aspirated, instead of aspirating air or clear fluid, he aspirated blood. And the liver is a very vascular organ, so that fits with a needle in the liver.
Baby P suffered a subcapsular liver hematoma as well. Is it the experts' belief that something similar happened in that case, or are different reasons being offered in the case of Baby P?
I can't comment on Baby P because I haven't reviewed that.
No more questions for me or for me? Oh, sorry.
Neil Connery, ITV News, is just Mark.
Right.
Have
Okay.
you any suggestion what Dr. Evans may have changed the cause of death to these three patients?
No, what he says is that air down the nasal gastric tube did not lead to the death, is what he said. But what he has done is that he's drafted a new report in Baby C, which I've said, and we've tried to get it, but we haven't got it. So we would like that disclosed as soon as possible, please.
Is there any reason given for you not having received that report?
No, not really.
When did you ask?
The day I found out in relation to the new report, which would have been, I think, about 6 weeks ago. Hello.
Hi, my name is Bisha from the New York Times. I'm just looking for some clarification on the CCRC case. So you said the applications are happening in tandem. Do you know when roughly?
Yes, they will be going in both of them this week. I know, because I'll be drafting them and putting them in. Hello.
Hi, Phoebe from Tortoise. There's been no mention of the two babies accused of insulin poisoning. Is that something you will be, because that wasn't dealt with by the Court of Appeal and that has been questioned since?
I've got 7 experts currently working on that, one in New Zealand, one in Missouri in America, and also a neonatologist, a biochemist. They all are working on it. But one thing that we can say about it is that test, the assay test, is wholly unreliable and should not have been used in a criminal case.
Sorry to have a second on that.
Of course.
Do you have a message for families of victims who are hearing this today?
Absolutely. It's always at the forefront of everything I do in relation to this. My job is to represent my lay client. My lay client said that she did not commit these crimes and this is a miscarriage of justice. That is my focus. But my experience in miscarriage of justice cases is when there are significant doubts, it doesn't go away. We will still be talking. If this matter is not properly reviewed, if this matter does not go back to trial and fresh evidence called before the jury, we will be continuing. And so the best thing to do is actually to have this matter before the Court of Appeal, go on the fresh evidence that we now have, and go back to a trial and present that fresh evidence before a jury.
Mark,
Hello.
in terms of the Court of Appeal's assessment of dowry evidence, you've said yourself in this statement they've already examined that.
They have.
How do you persuade them that they need to look at it afresh, that there's fresh grounds there? What's the difference, in other words, between the direct approach now and what Ben Myers and his team argued last time?
Yes, and they had some very persuasive arguments in relation to Dr. Evans, including a very senior Lord Justice of Appeal that contacted the trial judge during the trial to say that he had seen one of the reports in a previous case that he dealt with of Dr. Evans, and he made some very profound and robust criticisms about Dr. Evans' approach to evidence, and that formed part of the Court of Appeal, as you rightly say, argument on this. You know, I have never known in 26 years of being a barrister an expert to change their mind a year after the convictions on the cause of death and what they said to the jury. That, to me, is astonishing. And he has said that. He has said that these babies did not die this way, and he said it in a signed statement, which must mean that there is a different approach here. Now, don't get me wrong, I'm sure Dr. Evans is still going to say, well, Lucy Letby is guilty, and he has a different view and different hypothesis in relation to it. But the cause of death that was before the Court of Appeal is different now, according to Dr. Evans, and I think that is a profound issue that needs to be relooked by the Court of Appeal.
And these are comments that you've picked up from him in things he said publicly since?
No, this is a statement that he's written.
Can you just explain that to us a bit more clearly, because you said you hadn't seen...
Yeah, I can. There was a documentary on Channel 5 in relation to Lucy Letby, and he was given a right to reply. And in that right to reply is when he said it in a signed statement. Hi.
Hi, Victoria Berg from Sky News again. The juries in both of Lucy Letby's trials did not hear from any experts from the defence. Why was that?
I can't say why was that. I wasn't representing Lucy Letby at the time.
No,
let me come back to you. Let me expand. You are right. Of course I've seen the papers. You are right that there were defence experts called. What I don't know, and what I haven't asked, and what I haven't gone into, is why they weren't called. Because I came in 3.5 months ago as a fresh pair of eyes to look at this case, to look at the prosecution evidence, to look at the trial transcripts, and to see whether or not the prosecution team have got it right. I have now found fresh evidence that they haven't, from very experienced experts, but it doesn't stop there. My approach has been, you simply can't have a neonatologist, a person who works in neonatology, as your only expert in a criminal trial. What I don't want to do is rely upon the people that read the papers, that read the books, that gave the opinion. I want the authors of the books,
Surely
the authors of paper,
it would be
and that's what I've got.
interests in her defence if she'd have been able to call defence experts.
That may be so. I've given my answer. I'm fresh pair of eyes. I'm the new person here. I wasn't instructed 3.5 months ago. I wasn't instructed during the trial. All I can say is that I have fresh evidence that casts a significant doubt on the conviction. And can I say this, that I am in no way, and I will not, and you will not hear me criticise the trial defence team. She was represented by a very leading and very experienced King's Counsel, and you're not going to have me standing here criticising him.
Could I just ask Richard Taylor, you look visibly shaken and upset by what you've learned in relation to baby O. Has this been something that's really shocked you?
Yes. Yeah. It's I mean, what more can I say? I was very disturbed to read that report. Yeah.
Can I also add to that? I've instructed and used many times in many trials expert reports. The reports that I have received are the most comprehensive, the most detailed, the most forensic, the most thorough reports I've ever seen given by an expert. And I made sure that both these experts separately looked at the notes, looked at the reports, and came up with 2 separate reports before they came together to form one joint report. So they both agreed on the analysis before they sat in a room together and came up with a joint report. And that's what's going to happen with every baby that they examine. We're just at the start of the process, but enough for us now to go to the CCRC. Any more questions?
Can I just ask David Conn from Guardian, can I just ask Roger and, sorry, is it 2 Rogers?
No.
Richard.
Sorry, I'm a brain fade. Richard and Roger. Can I just ask you, as senior doctors, to actually become involved in this? And there are obviously many other senior doctors who are also becoming involved. Can you explain what your level of concern is? Because it's obviously unusual to be speaking out after convictions on this scale for eminent doctors to be speaking out like this. And can you explain why you're doing it and what your level of concern is?
Shall I get that?
Can you speak into the microphone, however you do it?
Probably come up to here actually. I mean, may assist because these mics are all lined up. You may also want to address if you're being paid back for this.
No, I'm not. Obviously, I live in Canada, and so my introduction to the Lucy Letby case was on visits to the United Kingdom, and so the first I heard about it was last year during the trial. I was incredibly surprised because if you look at the history behind this and you look at Lucy Letby herself, you see a nurse, and nursing is an altruistic profession where people, especially in this country, nurses don't go into it for the money. They go into it because they want to help other people, almost universally. And I think that applies to her. She has no past history of any antisocial behavior, any criminal behavior, any psychiatric problems at all. There is no motive. Her friends are all completely astounded, flabbergasted by the accusations that were made against her. And so that immediately, for me, brought up red flags. Said, well, what on earth's going on here? What's the evidence? And then when you go further into it, and the evidence is based on really one expert witness, a pediatrician who retired 15 years ago from clinical practice, who actually went and volunteered his services actively volunteered his services to the Crown Prosecution Service when he discovered that there was an inquiry going on. I do medical legal work. I don't go to the police or to lawyers to volunteer my services. They come to me. And I work for both sides. I work for the prosecution and for the defence, the plaintiffs and the CMPA in Canada. What do you want to say?
Yes, I think I'd add that I, as with many doctors who've seen evidence, and particularly the testimonies given by Doctors Bolin and Dr. Evans in court, I and they were absolutely astounded by some of the responses in almost every case that were given, particularly by Dr. Evans. He seemed to me to have broken the rules of the criminal procedure rules by always completely refusing to consider any other diagnosis than that which was the only possible diagnosis that he had come up with. And his duty to the court and to the jury was to give a range of opinion, and he constantly refused to do this. He had an opinion and he would not be moved. And of course this is not in the least bit surprising, because not only was he the lead prosecution doctor, he had worked with the police creating the theories. So it was impossible for him, when he came to give evidence, having created the theories, how likely is it that he could possibly have suddenly disagreed with himself? So he was not going to do that. And this is what has been so astounding to many doctors and experts who've seen evidence and who do not know Lucy Letby. I don't know her, and I think, Mark, you'll say it's almost unprecedented that 50 or 60 or more experts have come out of the woodwork to defend somebody on the basis of what we regard as absolutely appalling and unsustainable medical evidence.
Can I add this? Yes, that is absolutely right. All these experts have come forward and they're working day and night, some of them, drafting reports. Not one of them is being paid. Not one of them is asked for a fee. And again, that's unique, and also in my experience, they're doing it because they feel that something has gone wrong. We've got one in the audience sitting here, Dr. Tariq Ali, who is a consultant paediatric anaesthetist, who's also given some fairly robust views in relation to the issue of intubation. That's obviously a different subject, but he hopefully again will be given a report in relation to issues in relation to extubation and intubation. All right. Oh, sorry.
I was just going to ask a follow-up question, because your answers, Richard, you were talking about Lucy Letby herself quite a lot, and Roger, you were talking about the actual process of giving evidence in court. But speaking just about the medical evidence, and you said at the end, Roger, that you believe it's unsustainable and appalling evidence. Can you just expand on that? Because that seems to be the heart of it, that so many medical experts are actually looking at the evidence that went right through a trial in the court of law for 10 months and has gone to court of appeal about air down feeding tube and air embolism in these babies. And you all, many of you seem to be saying it's like this seems to be what's motivating you, that you just don't recognise it as proper medical evidence.
Sorry, can you stop me?
I understand that Dr. Evans actually proposed varying causes of death. Air down the feeding tube was one of them, but air embolism was another one. there are really no experts on neonatal air embolism, and so that makes it a little bit difficult to challenge Dowie Evans, because he hasn't seen it himself and I haven't seen it. I can give you my own impressions about air embolism, because some of these babies, after death, they actually did have x-rays performed. Now, air consists of 20% oxygen, 80% nitrogen. If it accidentally goes into a blood vessel, the oxygen will eventually get absorbed because the tissues will use oxygen. It's needed for life. So eventually the oxygen will get absorbed, but the nitrogen will persist for some time. And so when air enters the circulation, even some minutes later, or hours later even, I would expect the air to still be present in substantial amounts on the X-ray. And that wasn't the case, as far as I can tell. I haven't seen the X-rays myself, but apparently there were minute traces of possible air which were consistent with resuscitation attempts. Minute amounts of air will be seen after placing an umbilical venous catheter, because often a little bit of air gets entrained when an umbilical venous catheter is placed into a baby, and we can see that very clearly on an X-ray. It doesn't cause them any harm. So it would have to be a very large amount of air to actually cause harm, and one would expect to see that either on autopsy or on X-ray. That's as far as I can tell, because I've never seen a large accidental air embolism.
But when you're looking at the evidence, when you're looking at the babies and what the evidence was of the babies and their condition and the prematurity, and then you're looking at the evidence that was presented in the trial that was upheld by the Court of Appeal, presumably you're motivated to do this and to be here to talk about it because you also think that it doesn't add up and it's not sustainable. Absolutely, yes.
I've only gone through some of the babies myself personally. I looked at the retrial. It was a baby K, and I only saw the transcripts on that one, and also one of the insulin babies. I can comment on that one as well, as far as we've got. The remarkable thing about the insulin baby was that some information that actually only was released publicly in the Thirlwell inquiry, and that was the actual insulin test result, which went to Liverpool, and the test result shows a slightly elevated cortisol level, a sky-high insulin level, a low C-peptide, or a normal C-peptide perhaps, but also what was missed, an incredibly high blood glucose value. And that was completely inconsistent with the clinical findings on the baby, where bedside glucometer measurements were extremely low, and in fact that was why the insulin level was measured. And yet the blood sample which contained which was used to analyze the insulin actually read 999 millimoles per liter glucose, flagged high and verified. That information appears never to have come up in court. It was not mentioned by the prosecution experts. There was no defense report, and it was never even brought up in court. Why?
And Richard, can you tell us what that might be an indication of?
999 millimoles per litre is what the machine will give you if it's so high at the high end that it's off the scale. So it's actually higher than, I think, 54 millimoles per litre. It's just ridiculously high. It's just stupidly high. So we have two stupidly high numbers. The high insulin number, which was the one that the experts focused on, but the high glucose, which was completely ignored.
Does that point to guilt? So the argument of Dr. Evans is that points to Lucy Letby injecting in some way because I'm not a scientist, what the consequence of what you're telling us is.
So, okay, so the high glucose value in this sample it can mean a number of things. It could be a misprint. It could mean that the machine broke and churned out something. That doesn't really fit very well because it was verified. The most likely thing is that the sample was contaminated. It was contaminated, and that's what led to the very high glucose value.
So is this compelling evidence of murder?
In this particular case, it was attempted. The charge was attempted murder. It is evidence that the sample was contaminated, and therefore that makes it very suspicious, even invalid. If it was contaminated with glucose, it could have been contaminated with anything.
So in simple English, this is not compelling evidence of murder. This is evidence of a bad testing system.
It's evidence that the sample was contaminated, which means that any other results in it are suspicious. So it was
Meaning that it's murder or not murder?
Suspicious. We're talking about attempted murder, not
Okay,
yeah.
attempted murder or,
Yeah.
I think he means that suspicious is something.
or an accidental thing. Sorry.
I could clarify. It just means the sample should not be relied upon in court.
As a forensic test, you've got to throw it out.
Got it.
It was contaminated.
But can I just ask, you seem to be implying that there may have been some kind of deliberate contamination.
No, I'm not saying it was deliberate, but it was contaminated.
Can you clarify, please, which of the incident cases you're talking about, and also, please, can you just provide a bit more detail on baby C, the new evidence, and the failing placental function?
So baby C, I've only just glanced at that report, so I can't comment on baby C.
Which of the two incident cases are you?
It was baby. Is it baby F?
Yes.
Yes, baby F. Baby F. Yeah. And the I can pull it up. I can show it to you. It was in the Thirlwell report with the redacted name.
We're happy to send it to you afterwards.
Yeah, it's right there. It says 999 millimoles per litre. It's ridiculously high. And you'd get a result like that if the sample was drawn from a line that was running glucose, because the baby was receiving glucose. So if you actually pull back on the line that the baby was actually getting from, then you will get contamination with glucose. If that same line was used for the insulin infusion, which the baby had received a few days earlier, insulin will stick to the walls of the line, and that will also contaminate the result. But in any event, when you've got such a high glucose result, plus you've got other things like lipid and so on and so forth, it makes the insulin result really unreliable. And the insulin number was about 40 times as high as I've ever seen in my career. It's ridiculously high. Something obviously suspicious about it.
Sorry, Sam Roker, I need my questions to Mark. I mean, could you just recap for you what are the 2 or 3 most high categories of fresh evidence that you have now found that wasn't previously suspected?
Well, my starting point is, of course, the changing of the position of the lead prosecution expert, as I've outlined. In relation to O, it is that issue of the overventilation of the lung, the pushing down of the diaphragm, the moving of the liver that can be seen on the X-ray, the dropping of the HB, i.e. the red cell count, which is indicative of a bleed, going down during resuscitation, and the likelihood that the needle that was used as a cannula damaged the liver. That's quite important. But you know, the insulin cases are crucial because the insulin cases are the first 2 cases to which the jury reached a verdict on of guilty. So they are important, but it's also the 2 cases where albeit it wasn't the defence case at the trial, but Lucy Letby, under cross-examination, accepted the results. Now, the next question is, if you accept results, but we now found out they're unreliable. And if I can draw an analogy, it's probably not the best analogy, it's almost like a post office master pleading guilty to a crime they haven't committed because they got told the software was accurate, and now they're told it's not.
Yes, Lucy Letby was in no position to answer that question. She could not have known, she would not have had the medical knowledge to be able to give an informed answer to those questions.
And she also didn't see the result.
Well, she didn't see the important evidence.
Shows contamination.
No. All right, John.
Last question.
Okay. Did you want to ask a question as well, Stephanie? Was you going to put your hand up? No. Okay, John.
Lady Justice Thorwell has said that to question the conviction is noise. What would you say to her?
There's always my job, my role is to represent my client to the best of my ability. I see fresh evidence that casts doubt on the safety of the conviction. I have to do something about it. Lady Justice Thorwell is an incredibly experienced judge, and she has a very specific role within that inquiry, and I'm sure she's doing it to the best of her abilities. And if she finds this intervention distracting, then I can only apologise. But if I've got fresh evidence that says that my lay client convictions are unsafe, I have to do something with them. All right, no more questions? Thank you very much for coming today.